Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And this is my Facebook page, and you're welcome to join us. If you are in foreclosure, been through foreclosure, you can be with a bunch of like-minded people that help each other out. And if you have subscribed to my channel, thank you for doing so. Today we're going to talk about an important topic that everyone should really think about and in depth, and that is summary judgment that the bank will try to get on you. So let's take a look at this. This presentation is how to defeat a bank's motion for summary judgment. Most foreclosure cases are not lost at trial. They are lost at summary judgment, often because the homeowner didn't know how to fight back. Summary judgment is the bank trying to win without a trial. If granted, the case is basically over, but here's the key. The bank has the burden, not the homeowner. If the bank is the plaintiff and you're in a judicial foreclosure state especially, the bank has the burden of proof. In other words, they must prove their case in order to get a summary judgment. So let's talk about this. What is a summary judgment? In plain English, it means there are no disputed facts, and we win as a matter of law. What the bank is saying, we have the note, we have the mortgage, the borrower defaulted, we have standing, no defenses matter. This is what they pretty much do on a regular basis. Parts of a motion for summary judgment. Motion, the actual motion, the ask. This is the short front document, and it tells the judge, we want a judgment now without a trial. What to look for? What exactly are they asking for? Final judgment, amount owed, foreclosure sale. So your mindset should be, this is just their request. They still have to prove standing behind it, they still have to prove everything behind it. Memorandum of law is the next thing. This is where the bank explains why they think they should win. Usually includes legal standard for summary judgment, elements of foreclosure, and case law citations. Their version of events, what it really is, a story written by lawyers, not evidence. So what is a SUMF, which is called Statement of Undisputed Material Facts? What is it? Okay, material facts in numbered paragraphs. Example, number 1, defendant executed the note. Number 2, plaintiff is the holder of the note. And 3, defendant defaulted. And why it matters? Courts often treat unanswered facts as admitted. And this is huge. If you don't respond properly, you can lose automatically. So your response to the statement of undisputed facts, you need to either admit or deny each paragraph, cite evidence when denying. So you are not arguing here, you are accepting or disputing facts. Then they also file an affidavit in support of summary judgment. And this is where they try to prove everything. It's usually from a loan servicer employee or a document control officer or a records custodian. What it claims is personal knowledge, review of records, amount owed, and default. The problem, it is often boilerplate and weak. Key attack points. No real personal knowledge. Relies on prior servicer records. Hearsay. No foundation for business records. If the affidavit fails, the whole case can fail. Exhibits are important too, guys. These are the documents that they rely on. Common exhibits. Promissory note, mortgage or deed of trust, assignments, payment history, notice of default. What to check? Are they authenticated? Do they match the affidavit? Any gaps or inconsistencies? Key point, documents alone are not enough. They must be admissible. They also include sometimes a proposed order, which is a pre-written order for the judge to sign. Why it matters? It shows exactly what they want the judge to do. So here's a tip. Read it carefully. It tells you the end game. A summary judgment motion is just a package. The motion asks, the memorandum argues, the statement of undisputed material facts lists facts, the affidavit tries to prove them, and the exhibits support it. If any one of these pieces fails, the motion can fail. So the motion says we want to win. Memorandum of law, here's why. The statement of undisputed material facts. These facts are undisputed. Affidavit says, trust me, it's true. Exhibit says, here are the documents. Now, how counterclaims can defeat a summary judgment? If your counterclaims raise real factual disputes, the bank cannot win summary judgment because the case is no longer one-sided. What the bank must prove. To win summary judgment, the bank must show no genuine dispute of material fact. They are entitled to judgment as a matter of law. So if you introduce disputes through counterclaims, you are directly blocking summary judgment. Now, counterclaims have built-in disputes of their own. Counterclaims aren't just accusations, they are independent legal claims based on specific facts, often contradict the bank's version of events. So here's a translation. Your counterclaims create factual conflicts the judge cannot ignore. Types of counterclaims that create disputes. Lack of standing, wrong party, allegation the bank does not own the loan, dispute is created. Who had possession at filing? Was the assignment even valid? The effect, deadly attacks one of the bank's required elements, or directly attacks one of the bank's required elements. Fraud and forgery is another allegation. You got fabricated endorsements, robo-signed assignments. This creates disputes about authenticity of the documents or authority of signers. Judges cannot resolve fraud claims at summary judgment without evidence testing. Okay, FDCPA or consumer protection violations. If these are any of your counterclaims, misrepresentation of debt, false amounts owed, or even dual tracking if you're in a loan mod. This creates disputes about accuracy of debt, legality of collection conduct, payment or accounting errors. This is big, guys. Misapplied payments, incorrect default date, inflated balance creates disputes about whether a default even exists, which is huge. Breach of contract might be a counterclaim. Modification issues. Failed loan mod review. Violation of servicing agreements creates disputes about whether the foreclosure was proper. The legal principle. If resolving the bank's motion requires deciding your counterclaim, summary judgment must be denied because courts cannot weigh credibility. Courts cannot resolve factual conflicts. Courts cannot ignore competing evidence. Don't just mention counterclaims, connect them. Okay, so instead of saying defendant has counterclaims, say defendant's motion must be denied because defendant's counterclaims raise genuine disputes of material fact, including but not limited, then list the ownership of the note, the validity of assignments, accuracy of the debt, legality of servicing conduct. Show the judge the conflict. This is very important. You want to frame it like this. Plaintiff says X. Defendant's counterclaims allege Y. This is a direct factual conflict that cannot be resolved on summary judgment. Here's a powerful example. The bank says the borrower defaulted in January. The borrower's counterclaim shows payments were misapplied and the loan was not in default. That alone creates a factual dispute, and summary judgment must be denied. You don't have to prove your counterclaims at summary judgment. You only have to show that they create real disputes. And this is where people get confused. They think that they have to win the claim right now. They don't. If your counterclaims are strong, argue the plaintiff's motion is premature. Why? Because discovery is needed and evidence is in the bank's control. The number one rule, if there is any genuine dispute of material fact, summary judgment must be denied. Example of material disputes: who owns the loan? Was the assignment valid? Is the payment history accurate? Was the notice properly given? Is the account competent? Attack the bank's evidence. The affidavit is the weakest link. Who signed it? Did they work for the current servicer? Do they claim personal knowledge? Are they relying on business records? Key attack lines: lack of personal knowledge, hearsay, foundation not established. The note and endorsements. Examples: a note that is not endorsed in blank by the originating bank, a defective lost note affidavit, and a loan that is not attached to the note, or is what's called free floating, a loan modification that was not signed by the bank, a FHA loan that is supposed to be FHA, but the servicer lied, and it's conventional, a missing assignment in the chain of title, an assignment where either the assignor or assignee did not exist on the date it was recorded in the Recorder of Deeds office. They cannot prove they had possession at the time the case was filed. Very important. Other things. These are other things, guys. The bank did not follow the rules according to judicial foreclosure laws. The bank failed to send out the required 90-day notice. The bank failed to properly serve a copy of the summons and complaint. The bank filed an assignment after the foreclosure case was opened. The payment history is incomplete. The bank improperly charged fees. The bank improperly charged escrow manufacturing default by paying taxes and insurance improperly. The bank failed to properly apply the payment to principal and interest. The bank failed to properly apply Chapter 13 bankruptcy payments. The bank sent incorrect statements showing incorrect amounts due. The bank incorrectly charged excessive interest and or late fees. And you know, this list is just a short list. I'm sure there's many more things they did wrong. If the evidence is inadmissible, the court cannot rely on it, even if no one disputes it. Your response structure. Your opposition should include an introduction, statement of facts, your version, legal standard, argument sections, which could include lack of standing, defective affidavit, disputed default, or improper assignment, and then a conclusion, which will say genuine issues of material fact exist. Different ways to respond to a bank's motion for summary judgment. You don't just respond to summary judgment, you choose a strategy. Not every case calls for the same response. The strength of your facts determines your approach. Standard opposition, most common. This is the basic response. What it does, it argues there are genuine disputes of material fact. It attacks the bank's evidence. It points out legal deficiencies. When to use it? You have defenses. You see problems in the affidavit, note, or assignments. And the key goal is show the judge why the bank cannot win yet. You can also try to file a cross motion for a summary judgment of your own, which is a power move. Only if you've gone through discovery should you try to do this, guys. It's a strong move when used correctly. You don't just defend it, you ask the court to rule in your favor. When to use it? You have strong evidence that you've gotten through discovery. The facts are actually in your favor and legal issues clearly support you, like lack of standing. Example arguments. Plaintiff lacks standing at inception. Assignment is void as a matter of law. No valid default exists. If there are no disputed facts, the homeowner can win too. An important caution is, if facts are still disputed, your cross motion may be denied, but that can still help defeat their motion. Opposition plus supporting affidavit. This is where the homeowner tells their story under oath. What it does, it creates factual disputes and it counters the bank's affidavit. Here's an example. I made payments that were not credited. I never received a notice of default. I did not sign that document. This is powerful because affidavit versus affidavit equals dispute. No summary judgment. A motion to strike is another option to target their evidence. This is often overlooked but very effective. What it does, it asks the court to exclude affidavit, payment history, documents lacking foundation. Grounds would be hearsay, lack of personal knowledge, improper business record foundation, and the impact is if their evidence is struck, their motion collapses. Request for more time under Rule 56D or equivalent. This is a strategic delay but also legitimate. You would do that if you didn't get your discovery. So it says, I cannot properly respond yet because I need discovery. And when to use it, only if you haven't received discovery, like such as payment history, servicing records, or assignment documentation. Courts should not grant summary judgment before fair discovery. The bank is not entitled to win just because they filed paperwork. They must prove their case with admissible evidence, and if they don't, you have every right to force a trial. Okay, guys, this was our presentation today on how to fight a bank summary judgment motion. I hope it was helpful for y'all. And if you have any questions or comments, you can leave them below. Or if you need help with your own foreclosure, you can send me an email. My email address is foreclosurehelp777@gmail.com, and it's spelled with the number 4, as you can see right here. Okay, and as always, everyone have a blessed day.